各位委員
Members, we formed a quorum. May I call the meeting to order? That is meeting of the HLS panel. Information papers issued since the last meeting. We've received CB 1033/1617, an information paper entitled Proposed Legislative Amendments Relating to Procedures of Civil Appeals to the Court of Appeal, provided by the Judiciary Administration. Items for our next meeting. We have paper CB 41022/1617(01), our list of outstanding items, as well as CB 41022/1617(02), the list of follow-up actions. Since the last meeting, we've received a letter from Ms. Elizabeth Quat, dated the 19th of May 2017, to discuss the reduction in use of paper, improvement of the deal of the judiciary's website. And the letter has been tabled. Do members agree that we can include it on our list of outstanding items for discussion? All right, we'll do so. Item for our next meeting, scheduled for the 26th of June 2017 at 4:30. We have got the legal education and training in Hong Kong, implementation of the recommendations made by the Law Reform Commission, and proposal from the administration recently, and that is the proposal to write off an irrecoverable judgment debt. The three law schools do not provide sufficient places for PCLL, and this is already the 5th year in a row. We ask for a report from the relevant bodies. And the second is annual report from LRC on the latest situation in implementing the recommendations of the LRC. And the last is proposal to write off an irrecoverable judgment debt. The Home Affairs Bureau and the Legal Aid Department will consult us on the proposal of seeking the Finance Committee's approval to write off an irrecoverable judgment debt owed to the government by a formerly legally aided person. We welcome comments on items A, B, and C. Now for item A, every year we invite the LRC as well as the three legal schools to brief us on their progress of the respective matters. And on item 3, I'd like to consult members' views. Usually, the panel will not discuss individual cases. So, can the Secretariat tell us the rationale behind the administration's proposal for this item to be discussed at this panel? You're speaking too softly. On the 18th of May, the HAB sent an email to us asking for this item to be included. All information is already put here. I will discuss with them again to see whether for sure they want to consult the panel. What do you mean by all the information is now presented? Well, we've only got this simple sentence from the HAB. All right, I have to consider whether the policy panel really has to discuss this proposal from the HAB and whether this proposal has policy implications. If I find it appropriate, I will include it on our agenda. If not, I will turn it down, okay? Now for the next item, because for the next meeting, we have quite a lot of items, and I expect that the meeting will have to be extended to 7:30 p.m. because of two important issues, namely legal training and education by the three law schools, and second, LLC's recommendations. This is, of course, subject to members' interest in asking questions. Just in case many of us are interested, I just want to put in a little bit more time. So, members, do you have objection to extending our next meeting to 7:30 p.m.?
I don't see any objection. So the purpose is mainly to enable members to ask questions, because according to our past experience, when two main subjects are placed together, very often there won't be enough time for members to raise questions. So it's just to play safe. And also, I'd like to draw members' attention to this according to Rule 83A. With regard to the item under discussion today, if there's any direct or indirect pecuniary interests relating to the issue, please declare the nature of such interest before you speak. Next, we'll move on to item 3 on our agenda. That's the proposed arrangement with the Mainland on reciprocal recognition and enforcement of judgments on matrimonial and related matters. I'd like to invite the administration team and also the Bar Association and the Law Society representatives to join us. So please invite them to join us as quickly as possible. In the past, we have actually distributed papers to members beforehand. They are papers number CB-4-1022/16 to 17-03, Administration's paper on proposed arrangement with the Mainland on reciprocal recognition and enforcement of judgments on matrimonial and related matters. Second, paper CB-4-1022/16 to 17-04, updated background brief on proposed arrangement with the Mainland on reciprocal recognition and enforcement of judgments on matrimonial and related matters, prepared by the Electoral Secretariat. Now let's invite Mr. Peter Wong, Deputy Solicitor General, to, yes, please come in. So let's invite Mr. Wong to brief us on the paper on proposed arrangement with the Mainland on reciprocal recognition and enforcement of judgments on matrimonial and related matters. We'd like to have the latest update. Next, I'll be inviting the Bar Association and Law Society's representatives to give us their views. The floor will then be open to members' questions.
好，請問係Miss Johnson，因為係黃專員邊一位係
Who is to speak? So Mr. Peter Wong, please. Thank you, Madam Chair. You referred to our paper just now. That's paper CB-4-1022/16 to 17-03. That's an update on the proposed arrangement with regard to the reciprocal recognition and enforcement of judgments on matrimonial and related matters with the Mainland. Well, since the last meeting, we gave an initial response, and we've been liaising closely with the Mainland authorities on this, hoping to reach an agreement as soon as possible. In order to allay the concerns in our community. So we have now set out the initial arrangement. In particular, in para 5, we have set out the scope that we propose to be included in the proposed arrangement, in particular divorce and maintenance orders, as well as custody orders and so on. In particular, I'd like to point out that in para 5.5 is about orders for transfer of property and so on. I'll be supplementing on that later. Para 6 is about similar arrangements on the mainland, including divorce arrangements, property arrangements, and also maintenance arrangements and so on. But then given the fact that the two systems are very different, that's why we have to make sure that these are done on a reciprocal basis, as we explained last time. We haven't yet reached the final agreement. And Para 7 is about the administrative procedures, because as we pointed out last time, well, on the mainland, very often divorce would be done through administrative procedures, and therefore through this arrangement, we hope to be able to recognize administrative procedures done on the mainland. And also we can see that there are also customary marriages in accordance with Chinese customs in the past, and also the relative divorce arrangements and so on. So these would also be verified or confirmed by administrative arrangements. We would also like to achieve that under the new arrangement. With regard to property adjustment, given the fact that the two places have very different arrangements, and also with regard to matrimonial cases, well, for property is under personal ownership, so it's not about the ownership. Is about the parties to the litigation, and it would be binding on the parties to the litigation, and therefore on the mainland they can directly transfer the property to the other side, because on the mainland they apply the mainland system, which is different from that in Hong Kong. That's why we'd like to set out very clearly in the proposed arrangement with regard to the transfer of property on the mainland, that would be treated as if it's transferred from one side to the other side, and when it's put under our system, it would not affect the property ownership itself, so the parties would not be affected, and in the end that could only be implemented by way of an instrument. So that's parent 8 and 9. With regard to the differences in the two legal systems, we try to reconcile the two systems. And then para 10 also points out that the courts on both sides would not be able to vary the orders made by the original court, because that would also involve some complexity because of the difference in the two systems. So that's the brief outline of the arrangement. And para 11 and 12 is about the safeguards, because with regard to mutual recognition and implementation of such arrangements will be, well, there are some principles in support of that. First, we respect the procedures, and there should also be due process and also reasonable grounds for defense and so on. And that should also not be obtained by fraud. And if there is a judgment in place, we would also be prepared to follow that. And it also says out that on the mainland there are certain basic principles and also social common interests, and in Hong Kong we also attach a lot of importance to public policy. So under these circumstances, we should not be departing from those, and we would also, and there might also be certain reasons why we are not able to enforce the judgments on the mainland. And para 13 is about the levels of courts to be covered, and most of that would be dealt with in the district court level. And then on the mainland, it would be dealt with at the primary people's courts. And of course, higher level courts would also be covered. And then paras 15 and 16 and 17, they deal with the issue of finality of judgments. So in Hong Kong, whether it's maintenance orders or custody orders, that might be varied because of a change in circumstances, including the financial position of the parties and also the needs of the children, etc. So at the family court level, as to what's meant by finality of judgment, we believe that there is a need that where circumstances warrant, the judgments can be varied. That's why the courts in Hong Kong may vary such judgments, and that would also facilitate the mutual recognition and enforcement of judgments on both sides. And then on the mainland, because of the mainland system, well, there might be finality of judgments, but then we also said that there is also a chance that the orders might be varied by certain courts. And also in terms of the procedures for replication, for recognition and so on, Well, for example, if there are mainland judgments to be enforced in Hong Kong, they would also have to follow certain procedures. Similarly, Hong Kong's orders would also have to be enforced on the mainland after following certain procedures. And also, the total amount recovered shall not exceed the sum specified in the relevant judgment. As to the way forward, in response to members' clear indication last time that they'd like us to reach an agreement as soon as possible, the current target is that before the end of June this year, we should be able to sign the proposed arrangement. And of course, both sides would also have to go through internal procedures. For example, in 2006, with regard to the enforcement of the mutual recognition arrangement, we also had to go through legislative procedures. So on this occasion, only the judgments that come into effect after the implementation of the arrangement will be affected. Thank you. All right, the floor is now open. As we only have 2 members, I'll be giving you each 5 minutes. All right, Bar Association. Who would be speaking? Mr. S.K. Chen, Mr. Jeremy Chen. Okay, Mr. Jeremy Chen. Well, in fact, the Bar Association has had a chance to read up the paper for today's meeting. In principle, we agree to the proposed arrangement, and we are also very pleased that the administration has been able to do so expeditiously and efficiently. We hope that the proposed arrangements can be put in place after the due legal procedures. And as far as the profession is concerned, I think what's important is that Hong Kong's judgments can be enforced on the mainland, and that's why both sides will have to work hand in hand in order to make sure that this can be done as soon as possible, and will be prepared to offer help or resistance if there is any need. And when the legislation or bill is ready, we'll be happy to take a look to see what we can offer in terms of opinion. All right, if there is no further point to add, then Law Society of Hong Kong, Mr. Dennis Ho, Chairman of the Family Law Committee. Thank you. In June 2016, Madam Chair, the administration already proposed the arrangements, and the Law Society supports this. And we also propose that this should be done as quickly as possible in order to reach an agreement with the mainland. Because since 2006, there were already arrangements in place to deal with civil cases and judgments of that nature. But then, with regard to family laws and also the in matrimonial cases, the relief measures have not been in place yet. So, because of the close relationship between Hong Kong and the mainland, very often there would be matrimonial procedures, for example, the payment of maintenance, and also about children's custody or children being brought from the mainland into Hong Kong or vice versa. Well, we haven't got any systematic mechanism in place to deal with such cases. That's why, with the arrangement in place, it would help by taking the first step towards a satisfactory resolution of the problems, and therefore the Law Society welcomes this. Thank you, Mr. Dennis Ho. Anything else? If not, then the floor is open to members. First, Dr. Fernando Zhang. All right, the timer will start. 5 minutes, inclusive of both questions and answers. Thank you, Madam Chair. Concerning the proposed arrangements with regard to reciprocal recognition and enforcement of judgments on matrimonial and related matters, I support the direction, because we do have a lot of cross-boundary marriages, and during the past few years, I think some 30% or even up to 40% of the marriages registered in Hong Kong involve parties from both sides. And also, if you look at divorce cases, during the past few years, about 20 to 30% of the divorce cases involve parties from both sides. So for such arrangements, whether it's divorce and also arrangement of properties and also maintenance orders or custody orders and so on, if there is no mutual recognition or reciprocal recognition, then there would be problems in terms of enforcement. If there is reciprocal recognition, then certain basic values and principles will have to be balanced. And I think this is good. So, all in all, I would like to say that I support the overall direction. But then, when I discuss this with some groups, in particular for women who are the victims of domestic violence, well, they are somewhat concerned.
Because there are the way they handle it in the mainland may be different. For instance, if the child is not yet weaned, then during the divorce, the mother will have the custody. So the son may go to the father and the daughter may go to the mother. And therefore, siblings may be given to different parents for custody. And if there is such an order in the mainland to be enforced in Hong Kong, I don't know whether this will be entitled to the safeguards, because this is naturally or obviously against our public policy or against social and public interests. And in the mainland, different provinces and cities may have different arrangements for applying for divorces and so forth. It's just like applying for a one-way permit to Hong Kong. Different places in the mainland have different treatments. In some places, applications are expeditiously processed, but in some other places, they may have to pay a bribe. And it's hard to get the evidence if the one in the mainland side is well off enough to bribe his way, and then if the order has to be and the judgment has to be enforced in Hong Kong, then what are the safeguards? Mr. Peter Wong. Yes, if bribery or corruption is involved, evidence is one thing. But if there is corruption, that would be among one of the grounds for the safeguards, because this is about public policy. And I think the same applies to the mainland. And when we consider from the perspective of public policy, we will consider what's in the best interest of underage children. Because Dr. Zhang mentioned a specific example. In the mainland, a daughter and a son may be separated at a certain stage. So we usually will not reconsider the merits of a case unless they are really fundamental and critical principles. So we will discuss, we will communicate with the mainland as for what is the best interest for underage children. In Hong Kong, under some special circumstances, two siblings may also be separated. The custody may not go to one single parent only. usually the party to the court to enforce the judgment will not consider the merits. Rather, the court may consider whether there are grave public policy principles involved. And we also have to look at the circumstances of the case. Now is my time. In the past 20 years, I have had the opportunity to deal with legal disputes arising from cross-boundary marriages. I'd like to mention a few scenarios to see whether the arrangements will help to address that. For instance, before the marriage legislation was reformed in 1971, there were concubines allowed in Hong Kong. So concubines in Hong Kong are legally protected, and men may obtain a certificate of to prove that he was a widower, and then he went to get married in the mainland, and subsequently his concubine was identified, and then he might claim that his relations with the concubine was very poor. And for the spouse in the mainland, she might think that is a legal marriage, and however she couldn't inherit the property of her husband after he had passed away. I think this is a typical case in Hong Kong, because some of the elderly persons in Hong Kong are in this situation. And secondly, I share Dr. Jiang's concern. I have dealt with a case. A mother came to seek help. Her husband was a mainlander and in a better financial position than she is. She had a pair of twins, 5 years old, and then the two were the parents shared the custody of one each. But after our intervention, both daughters went to the mother because she had been looking after them all the way. So in the mainland, they do not consider that the twins grew up together, so each parent got to have one twin. And then because the husband in the mainland was also better off, and so he might have custody of both children. So I'd like to know whether this can be addressed. And thirdly, I have dealt with a scenario where one parent passed away in the mainland, and the surviving child is less than 12 years old and being looked after by relatives in the mainland. The grandparents in Hong Kong wanted to take over. However, it was very difficult, even though they might have a certificate, a child ID card, so on and so forth. So if you discuss with the immigration department, the police, when cross-boundary marriages are involved, it's very difficult to deal with things like the visa and other things. Well, the three questions raised by the chairman was very interesting. First, concubines, and this is about a recognition of Chinese customs and traditions, and this is also about the validity of or the legal status of concubines in Hong Kong. Para 5 is about the scope. So they're mainly about divorces, whether it be a customary marriage or marriage after the reforms in Hong Kong. Both are accepted in the mainland. So both parties would accept the administrative treatment or procedures of divorces, but the case you referred to was a wider issue. This time we'll focus on recognition of divorce and related matters. This is an improvement because we can confirm the recognition of divorces through administrative procedures. And as for custody of children, I can only say that our considerations include public policy and also the best interest of the child. But this still there are differences in the judgment and legal principles of the two places. For mutual recognition, we will not revisit the merits of the case. We will see whether there are procedural justice, and whether there are great principles involving public policy. But we've already put in appropriate safeguards. But we have to understand that the two places have differences. And even for matrimonial judgments or other family matter judgments, we have to respect the judgment itself unless there are serious flaws in the procedures. And third, the supporting measures. After the proposed arrangement is in place, now, Madam Chair, you mentioned the question of visa. We will deal with it according to our established policies. But there may be abduction of a child. We want the right of custody to be recognized by both courts. And if it's confirmed that who has the right of custody, then the child can be returned to Hong Kong. I think this is in general an improvement. It is an important starting point, but there is room for improvement. When after implementation, we see how the system can be improved, and we will not hesitate to discuss with the mainland to improve the system. Regarding public policy, now some civil judgments in the mainland might not be enforced in Hong Kong because of public policy consideration. Yes, public policy is important under common law, so we will adopt similar principles to deal with that. Mr. Poon Xiuping, thank you. Yes, the proposed arrangement is acceptable, and under para 11, we know that the agreement would hopefully be concluded in June. And in Hong Kong, we need local legislation to implement the proposed arrangement. I'd like to know whether the administration has any legislative timetable. Yes, we will have to enact our own legislation. In 2006, we signed an agreement and it took effect on the 1st of August 2008. We hope to be able to draft the relevant bill within a year, and we hope to present the bill to the Council by the end of next year. Next round, Dr. Fernando Zhang and myself. 2 minutes each, okay? Dr. Zhang. Thank you, Madam Chair. I am really worried hearing what the Deputy Solicitor General said. In your example, Chairman, if the custody right of the twins was given to two different parents, according to Mr. Wong, our courts will not consider the merits. They will look at whether there are procedural problem or any bribery or corruption, and whether crucial principles are involved.
But then the fact that if the twin sisters have to be separated and be taken care of by different parents, well, that would depend on the actual circumstances. But then, according to what you said, you're not going to look at the actual circumstances because that's been looked at by the Mainland Court, and a judgment has been made on that basis. So you would not be adhering to the principle that siblings should not be separated. So if indeed we had such a case whereby the siblings would be awarded to different parents, all right, you are a CPPCC member, all right, by writing a letter you might be able to help. But then if if one of the parents is not able to write to one of the CPPCC member, then he or she will not be able to get help at all. So what I'm concerned about is that how are we able to prevent this from happening? Because on the very least, the party should be allowed to make a representation on behalf of the underage child, because we always have to act in the best interest of the children. So how can that be achieved so as to ensure that this sort of judgments will not be executed or enforced? Well, I would have confidence that this would not be enforced in Hong Kong. But then what about on the mainland? Well, with mutual recognition, I hope to be able to prevent the situation whereby children might be abducted. Well, forgive me for being long-winded, Madam Chair. Yes, you can continue. Okay, if one of the children has been taken away from Hong Kong to the mainland, then there is no way that you can go after them, despite the fact that that parent on the mainland does not have the custody right. But then on the mainland, there is no such concept as abducting or kidnapping of children. So it would be very difficult to enforce any Hong Kong judgments. So if one of the parents unilaterally took a child back to the mainland without the consent of the other party, what was mutual or reciprocal recognition in place, how are you able to ensure that that child can be returned to Hong Kong, where the parent in Hong Kong has the custody right, or the parent who has abducted the child to the mainland might be subject to appropriate sanction? So how can you ensure that? Yes, Mr. Wong. Well, I think the honourable member raised two questions just now. It's about the arrangements concerning custody and also when two children are involved. I think the overriding principle should be that, well, we have to respect the judgments on both sides. For example, if the court in Hong Kong made a judgment, we would also hope that the mainland court would help enforce that judgment. And of course, the court would also have to consider the principles that are at stake including what's in the best interest of the child. And the honourable member just said that, well, this is of critical importance. That's the public policy in Hong Kong. And also for underage children, we always put their best interests in the consideration of any judgments. But then in very special cases, if we detect very serious problems, for example, if it's not in line with the best interest of the child concerned, then we might consider not enforcing a particular judgment. But then that would still go back to the merits of the case and also the principles under consideration under the two legal systems. That's the same for other cases. With regard to how we can put in place support measures to support this arrangement, well, to a very large extent, we also hope to deal with a situation whereby children would be taken away against the judgments, because we will have to make sure that the judgments would be enforced by the mainland court. For example, if the Hong Kong court has already ruled that this child belongs to his or her mum or mother, and if the father takes him away to the mainland, then we will have to ask the mainland court to enforce Hong Kong's judgments, and we will have to make an application in Hong Kong, and then it's for the mainland court to execute or enforce that judgment. All right, it's now my turn. Well, to follow up on my earlier question, in fact, I do understand that when it comes to matrimonial judgments with reciprocal recognition, you also have to ensure that it's in line with the principle of due process, and also you will have to act in accordance with the overriding principles and policies. Well, for the Immigration Department's policies, well, if you adhere to the past policies, once you start with the reciprocal recognition, you will have to think a bit more. You should not adopt the past approach like what I said in the examples that I gave. And for the cases that I've followed up with, well, there were two twin girls, and they are already quite old, 11, 12 years old, and they are already quite mature. But then that cannot be done on the principle of due process. So in terms of resources and in terms of the help that you offer, well, when a couple divorce, it would be rather panicky, and they might approach lawmakers instead of you. So what kind of help can you offer to them? And on the mainland, they also might need to set up a counterpart mechanism. So it might not be abduction per se. It's just about the relationship between the two. I think the most important thing is to think about the best interests of the children. So after the reciprocal arrangement is in place, you will have to ensure that proper things are done. So even if you have a court in place to deal with the situation, even if you have the court of second instance or third instance, well, they might have reviewed the case. Still, these problems may not be resolved in line with the normal procedures. So it's just a mechanical enforcement of the mutual recognition arrangement. So can you take it up with the mainland authorities, the immigration authorities, the welfare authorities, and so on? There might be a chance that they might be more familiar with such cases, and therefore they might be more experienced in how these cases should be dealt with, so as to ensure that the proposed arrangements would be implemented satisfactorily. Madam Chair, I don't want to give you an impression that we would just follow very rigid procedures. When a new arrangement is in place, we might need to put in place other support measures. For example, the SWD would be very experienced, and therefore we have been maintaining very close liaison and communication with them to seek their advice. And also for the welfare sector, we've also been working very closely with them because of their rich experience, and we hope to put in place the best arrangements. But then I'd like to stress that well, despite the fact that the reciprocal arrangements might have been able to achieve some breakthroughs, it will not be able to solve all problems. But then at least we have made a head start, and then we'll be able to deal with situations whereby children have been unlawfully taken away from their parents. Yes, I agree. I hope that on the mainland you can also request that a counterpart body be set up to deal with that. Yes. Bar Association and Law Society, anything that you like to add? If not, yes, Fernando Jiang, speaking in the third round, also 2 minutes. Yes, thank you, Madam Chair. I have a practical concern that I'm most worried about. When these couples divorce, where there might have been physical violence involved. Well, I'd cite a classic case. All right, the husband might be more well off, and if he wants to continue to control the family, or even his wife, when he goes to the mainland court to file for divorce, and also for maintenance and custody orders and so on, and after he has got all the papers, because of the difference in the legal systems, he might be able to do so more expeditiously. I understand that in some provinces and cities, they might be able to get the judgments very expeditiously. In particular, for those with means, they would be able to do so or do things more quickly. So it's quite different from the system in Hong Kong. But then the judgments will have to be enforced in Hong Kong, and as he has the means, well, assuming that this is a family with a background of or history of domestic violence, and this guy has already got these judgments in his hand, so that he has got the right for these judgments to be enforced in Hong Kong, and there is no reason why Hong Kong courts would refuse to enforce these orders. Well, that would be worse off than without the reciprocal arrangements, because he would not have any right to disturb his divorced wife and family if there's no such arrangement. I don't want this to happen, but what if there is this financial gap between the parties to the litigation, and this might result in an abuse of power by the party with means, and what can you do to help? I don't want this to happen, and I'm most worried about this. Well, Para 11 is also one of the safeguards, and to a certain extent, this can deal with this. All right, if litigation has already started in Hong Kong for divorce, but then for the party with better means, and if he starts the procedures on the mainland, and if he gets the judgments on the mainland more expeditiously, then 11.3 would deal with this situation. Well, such judgments cannot be enforced in Hong Kong, because if the action has already been started in Hong Kong, and if the other party try to get a course of action on the mainland, so that he can get a more favorable judgment, well, to a certain extent, that would not be enforced in Hong Kong. I hope that would deal with the situation that you just referred to. Well, in other words, he will try to get the judgments first, because the party with means will be able to get the judgments more quickly. All right, Mr. Wong has already responded to your question, and would like to make sure that the arrangement would be more in line with human rights and be more humane, so to speak. Okay, if there are no further comments, then I think we'll wrap up our discussion here. Next, moving on. Item 4. Launch of Hong Kong e-legislation. 2 papers. CB bracket 4 1022/16 to 17 bracket 05, and then we have the Electrical Secretariat background paper also on launch of Hong Kong e-legislation, and our members have also specifically requested that this be discussed at today's meeting. We have also invited Ms. Teresa Johnson from the DOJ to walk us through the paper. So, Ms. Johnson, please enter the conference room. And next, we'll be inviting the Bar Association to speak on the subject before the floor is open to members. So, Ms. Johnson, over to you. So please walk us through the paper.
Discuss the launch of the new legislation database, which is called Hong Kong e-legislation, or HKEL for short, and which aims to provide easy access for up-to-date Hong Kong legislation. For those members I've not yet met, as the chairman has mentioned, my name is Teresa Johnson and I'm the law draftsman. With me are three colleagues who've been involved in the database project: Mr. Gilbert Moe, Deputy Law Draftsman, Mr. Edward Wong, System Manager, and Ms. Carmen Kwok, Senior Government Counsel, who, should members find it useful, stands ready to demonstrate any aspect that would facilitate our discussion. In November, it will be 20 years since the first legislation database, Bilingual Laws Information System, or BLIS for short, was made available. As you know, its status is for information only, and it is only the hard copy loose leaf edition of the laws of Hong Kong, which can in fact be up to 9 months behind in terms of updates, which has legal status. Also, BLIS's technical platform is becoming outdated, so new secure online platform is necessary to enable access to copies of legislation with legal status. These are for use not only by the profession but for the general public. So the proposal to develop this new platform received the support of this particular panel in 2010, and the panel has remained interested and informed in progress through papers that have been provided in 2014 and in January and May 2017. In building the new system, the Hong Kong Legislation Database User Liaison Group, which is mentioned in paragraphs 3 and 4 of the paper, provided input from the user's perspective. May I mention that Mr. Martin Wong, who is here today, was the representative from the Hong Kong Bar Association on the group, and I thank him for his valuable contribution to the project. Reference was also made to the legislation databases developed and being developed in other jurisdictions. HKEL is a work in progress. It currently contains copies of all legislation in HTML format, that's short for hypertext markup language, and it gives legal status to approximately 8% of all chapters. The system and the documents themselves make it clear whether or not something has legal status. HKEL also has more advanced functionality. For example, there are new features. They allow users to view legislation in monolingual and bilingual mode, and either on whole chapter or individual section basis. If it may assist, we could show that, or would you like me just to continue, Chairman?
Okay. We knew that there was a briefing before, right?
Yes.
我諗呢就
I think I would like to hear from the representative of the Hong Kong Bar Association, and then we'll give the floor to members to express to you why we find the new system so difficult, and then we'll give you the floor to supplement. Is that fine?
invite Mr. Martin Wong on behalf of the Bar Association, please.
Yes, Chairperson. I've looked at the brief notes prepared by the Department of Justice, and I've looked at, in particular, paragraph 9 of that note, which specifies 5 areas where concerns have been identified. I can say immediately that items A and C are also shared as a concern among my profession. Of course, there's not been a formal survey done as to this e-legislation database as such, but through discussions I've had with my colleagues, both in chambers and during general chit-chat, these two come up most often as concerns. And I try to explain to them what underlies these two concerns. The first about speed. It's a much more complicated system, as I understand, from from the time I spent with the liaison group. So it's understandable that the whole system will need more time for anything to load. It used to be a very crude system. If you just press, something in HTML pops up. Now it has to go through a lot of background searching, arranging before it pops up. I think people find that not as satisfactory as before, but as I said to them, there are benefits to be gained by the functionalities and also the security of the whole platform. And as for user interface, it's even more a question of habit. People are used to seeing the Bliss interface. And if something has been there for multiple decades, people get incredibly used to it and attached to it. And so anything different, they find them difficult to use. So what I explained to them was just give it some time. I have to confess, I sometimes find it, you can call it frustrating because it takes a bit more time to load and to find things. But then once you've found it, a lot more is on the screen than before, and you can get through to the exact bits you want quicker than before, of course, if you know what you're looking for. So I think it's a matter of time that people will get used to it, and once they have, they will start to appreciate the benefits. And of course, underlying all these, the technicalities, is I think, the purpose of having a formal, official version of everything online. That's the ultimate goal, to eliminate the paper version, which I find incredibly cumbersome. In my 10 plus years of practice, I just found myself on many occasions too lazy to go to the loose leaf bundle and just rely on Bliss. But in fact, properly, we should not be relying on the Bliss version because it's not official. But with this new platform, we have something official online available to rely on. So I think in the long run, this has to be done. So you can say it's growing pain that people are going through. So that would be my view.
Okay, thank you, Mr. Wong. 跟住落嚟就係我哋委。
Thank you, Mr. Wong. Now, the floor is open to members. Mr. Charles Mock, Mr. Dennis Kwok, Ms. Tanya Chen, and myself, 4 members. We will have 4 minutes each to start with. Thank you, Madam Chair.
This panel, because I'm actually not a member. I'm actually not a member here, and I'm not in the legal profession, but even I have heard a lot of negative comments about this system from my friends in the legal community. And I do understand that it does take some time for users to get used to it. But I think some of the listed concerns, such as these 5 that were referred to just now in point 9, in fact, I actually hear quite a lot of people talking to me about B and D in particular. But my question, first of all, is that you mentioned in the document presented to the panel, you did say that there is this liaison group. I'd like to know, how many members are there, and are there any additional focus groups or user survey done before or after the system went on live? Because I think that is very important, particularly when you are met with very picky and demanding users like lawyers, and I meant that as a compliment because the professionals are often like that. So I really want to know, whether or not you have done enough in terms of, this kind of, getting response and opinions from the actual users. And of course, as you are putting in more revision right now to tackle some of these concerns, are you planning to expand the liaison group to a larger group of potential or actual users? And the other question I have is, when you mention in point 10 that you're working with the contractor to solve these technical issues, I think some of these might be technical issues, but some of these might be specification issues that they weren't in the specification before. So now that you are asking the contractor to look at these issues again, are you going to incur additional cost in doing that? And in fact, if these new additional work are stuff that are not previously in the specification before, then probably the contractors they really should charge you extra for doing these stuff. And I'm not. I mean that partly, of course, because we see that a lot from government or other companies contracting to an IT company, and they always tell them you have to do this, you have to do this. But in fact, it wasn't even in the original specification. So I want to make sure that these new additional work that you are asking them to do, were there things that they didn't come through, or these are new additional demands from the government?
Ms. Johnson, please.
If I may, thank you for that question. If I turn first to the issue around consultation, September 2013 was when the liaison group was established. It comprised representatives from both legal professional bodies, the Bar Association and the Law Society, from the Judiciary and also from the Legal Service Division of the Legislative Council Secretariat. So it was a small focused group. We have no current intentions of expanding that group, although that may be something that we could look into. We are finding that we receive very good feedback through the email address that is on the bottom of our website in terms of the contact us. So that is the way in which we are currently proceeding. I should say that because of the relationship that Hong Kong has with other jurisdictions in this region, there is a regular meeting between the jurisdictions around legislative databases, which is quite a specialised area of IT. So we have learnt lessons also from what is happening in other jurisdictions. Turning to the question about specifications, certainly there are some issues that are just technical issues that were discovered only after the system went live, and that primarily relates to the loading time for long documents or for unusual documents. And we are working closely with the contractor to rectify that issue. Some rectification has already occurred, at least in an interim sense. In terms of the cost associated with, for example, changes to user interface, that is really just an ongoing issue with the contractor. Some of those may well be covered as matters within the nursing period, but we will just abide by the contract in relation to that.
Just one.
對唔住，4分鐘。
I'm afraid we can only have 4 minutes each in the first round. I'll allow the second round. Second is Mr. Dennis Kwok.
Ms. Johnson for coming today. To be fair, I think I have to say that Ms. Johnson and her colleagues came earlier, I think this week, to demonstrate to us in LegCo as to how this new system is supposed to work and all the wonderful new features that this system has, which Bliss doesn't have. I'm beginning myself to learn how to use this new system, and I have to say it's not easy. And I have received a lot of comments, especially from the members of the legal profession, as to how difficult it is to use this system. And as the representative of the bar has kindly pointed out, that it may be it's a time issue, that it takes time to learn how to use the system. So I just want to know, apart from the seminars that you would be giving, for example, you're coming to my Friday tea gathering to give members of the legal profession a demonstration, and Tanya Chan is free to come if you're interested. And I think those learning or demonstration would be very useful. I hope members will come. As I understand, a lot of people have signed up for the gathering. What other educational seminars or demonstration that you think you could do for members of the legal profession and members of the public to learn about this new system? What kind of plans do you have in place? And in order to do it properly, you may need further funding to conduct these educational seminars. So what kind of plans do you have?
Well, our current plans are to continue to, support our users in making the transition to the new system. We have had approximately 1,000 people already attend training that has largely been conducted by Ms Kwok. As Mr Kwok mentions, we will be attending his tea gathering this Friday for a further training session, and we will continue to provide training as requests are made and as we see opportunities. In addition to that, on our website we have some training tools that are readily available for people. So there are easy guides on that. There are also multimedia clips there. It's certainly a matter that has occupied our attention in terms of what more can we do to assist users in their transition from BLESS through to HKEL. But at present, these are our plans.
Okay.
Thank you.
OK， 咁跟住就係阿陳淑莊議員。
Ms. Tanya Chen.
你即係我唔係呢個會嘅成員，但係你都俾我發言啦。咁因為我就頭先我嘅業界代表郭榮鏗議員已經代表咗我發言。咁我而家今次嘅身份咧，主要咧就係收集咗一啲同學嘅意見啦，同埋一啲尤其是係職員嘅意見，立法會裏面職員嘅意見。因為我哋好多時候咧都要針對地咧係做一啲法律嘅一啲研究啊，或者係一啲。
Very often we have to conduct legal research and investigation, and under the new system, to a certain extent, that would provide greater convenience to the users. For example, in different pieces of legislation and on different provisions, we can single them out for investigation or research. But then there's a problem. When you try to print that out, it's really a painful process because between the lines, the line gap is very big, and also the font size would be so large. The font size would be too large for the naked eyes, and of course, well, under the BLISS, the font size might not have been in line with the legal requirement. But then at least for that, under that system, when we try to print out, we can save a lot of paper, because I remember even Elizabeth Quad also wrote saying that well, when we try to print out the legislation, is quite paper consuming, and in particular for me myself, I'm more used to using hard copies rather than using the digital device to jot down anything. So when we try to use this is called, other than the HTML format, there are the formats available so as to facilitate printing and also to make to save paper more easily. Well, we try all means, and I've already taken advice from the IT experts. And also, you said that there would be seminars to teach us how to use it, but then have you got videos or video clips, or can you do it in a more interesting manner? For example, can we ask the Secretary for Justice to do the demonstration himself so as to make it more interesting, so that more people would be attracted to watch it and so on? Yes, Ms. Johnson?
I'm answering to that particular question to Ms. Kwok.
係咪郭文儀女士？係。
Ms. Kwok, yes. First of all, I'd like to thank the honourable member for her question. Well, we understand that the younger generation are not used to reading up manuals. That's why we have already produced video clips so that we can show it on the multimedia channels. We'll try to make it more interesting. With regard to printing difficulties, well, for verified legislation, all right, there is a green click. That is the PDF version, and also we also have the for information only version. And after taking on board your views, we are trying to come up with more PDF files. Once you have the verified PDF copies, you have two choices. Yes, I know. because that's to respond to the needs of the profession, because for the younger people, they like the font size to be smaller, to be more eco-friendly. But then for the older people, they prefer to have bigger font sizes. So the default font size would be the big font size. But then it's okay, because you can also choose to have 2 pages printed on the same page, so that you can have a lighter version where the font size will be smaller. And then similarly for HTML formats, well, you can also choose the font size. You will still be able to print out the version in line with your needs. You can have 2 columns with very small font size, so that the Chinese would be on the left-hand side and English would be on the right-hand side. And the setting can also be scaled, and you will still be able to get a very nice format. So we can also supplement that on our FAQ, so that the users will find it easier to understand how they can print out the provisions. Alright, next is my turn. First, what I'd like to say is, well, last time, well, your pre-meeting was very successful. At least our assistants, when they came back, they did not criticize the system so severely. But then it doesn't necessarily mean that the system has improved significantly. I think one of the views that we have heard is that given the amounts of criticism, apparently some improvements have been made. One of the reasons is that for the old system and the new system, they are still being used in parallel. But then, by the time when the old system is phased out, will the new system still be able to meet the needs of the market? So that's the question that I'd like you to address later. And also, when compared to the old system, are we able to ensure that some of the advantages of the old system will be migrated to the new system? Because well, I also created a database myself some years back, and I tried to put the Chinese and English versions of Chinese laws in parallel. So that was 17 years ago, back in year 2000. And now our system. Well, given the fact that this has been in place for such a long time, you want it to be expeditious, efficient, and accurate. But then we have heard from the users that they would have to print that out batch by batch, and that would be very time consuming. So how are you going to review that? Because well, for the users, to be honest with you, well, some lawyers are using the system themselves, but more frequently it's used by the research department, and then it's the libraries in the universities, and of course for law firms, they have their own libraries. So these people would be the main users of the system. They are actually experts in the field. So when you try to tell them what the merits of the systems are, well, for us lawmakers, we don't really use it ourselves that frequently, so we just hear from them. So how can you convince them that after the new system is in place, and by which time the old system can be phased out without being used in parallel, and still you'll be able to address their concerns and grievances? There have been a lot of grievances expressed out there. And also, so many resources have been put into this new system. And initially, when we picked the system, in other jurisdictions, have they already used this with very successful experience? And how come, when we try to apply that here in Hong Kong, how come we have encountered so many problems?
Yeah. Ms. Johnson, you want to reply?
Yes,
yeah.
Thank you. May I just say, Madam Chairman, that what we're dealing with really is cutting-edge technology. When New Zealand, for example, began a similar process, and they were doing it in one language only, using one alphabet, not 3, it took them 10 years. We are now 4 years down the path towards developing the database of our dreams, if we might call it that. So I think that really we are at a very early stage in terms of user acceptance of it and familiarity with it. You mentioned the main user groups. We have in fact also conducted training for law librarians from the universities and for other people who are particularly the experts in terms of undertaking legal research in legislation. I will leave the question about batch by batch printing to Ms Kwok because I'm not sure that I've had that particular experience.
Will you speak closer to the microphone? Yeah, thank you.
Certainly, sorry about that. So when it comes to the advantages of the old system versus the new system, I think that we are very close to actually ensuring that we have both of those. There is still going to be the need, though, for users to become familiar with how the interface works. While some changes will be made as the result of user feedback about that sort of user interface, we need to balance the needs of different users, the very sophisticated user and the user who is not so sophisticated. So we will be striving to do that. And we are very much focused on the needs of our users. I mean, this is really the whole purpose behind all of the sessions that we have done. I mean, it is only for the users that this database is being created, and we welcome feedback and we welcome the views of everyone, including the views, obviously, of the members of the panel here.
Okay. Hi.
Either Ms Kwok, before you supplement, because I have to be fair, because during the first round we still have Mr Holden Chow who would like to speak, so I'll be giving you the chance to respond. So my question has not been answered yet, so I'll be asking you to answer that again. All right, Holden Chow. Thank you, Madam Chair. I think some members have already spoken on that. I'd like to reiterate that, well, with the new website, since its launch, I think for the mobile version, many of us from the profession have indicated that it's been very hard to browse the site. So can the government go back and take another look? Can it be improved? Because honestly, other than the desktop version, I think for the mobile version, many legal practitioners are using that, but then if it's still so congested, if it's still so hard to browse, then it would affect our work very substantially. I'm sure some must have expressed that to you already, so I wonder if you can improve on that. Can you spend more time on the mobile version to make it more user-friendly? Ms Johnson or Ms Kwok? Well, this is the first time that we got this feedback that the mobile version might have problems with connectivity. In fact, we have got an app, and that would automatically find out the size of the screen, and then it can adjust automatically. So the mobile version has that function already. So we'll go back and take a look to see how that can be improved. Thank you. Okay, after the first round is now the second round. All right, Mr. Charles Mock.
A follow-up to what I asked in the first round is that about the liaison group or focus group, I do just want to make a suggestion that please try to see whether you can open it up further to solicit more users from the profession, from the community, other than just official representatives from a number of groups. That might give you a wider spectrum of opinions and suggestions and so on. Sometimes if you just simply rely on people clicking on a certain link or whatever to tell you what they feel, you know, that you're probably not going to get the full picture. People tend to complain offline very much. But anyway, I do think that I do agree that there will be some a little bit of time that people need to get used to it and all that, and for the system to be improved. But I do just want to make a suggestion that please try to open up the channels that you are receiving some of these feedbacks. That will be helpful. Thank you.
Okay. Yeah. And
for his suggestion.
Okay. 好，咁跟住咧就係涂謹申議員係第一輪咧。
Next, James Stowe asking in the first round 4 minutes, including both questions and answers. I don't need that much time, Madam Chair, because as a lawyer, I took part in a seminar. Well, initially I just joined to get the credit, so it's one of the CPD courses. But then on that occasion, I think it's Miss Carmen Kwok who chaired the seminar, and she was so remarkable that even for me, who's an idiot in these things, and I noticed that, well, all of a sudden I found myself to understand everything. And of course, I might not have understood everything, but then she managed to impress me a lot, because she made things so simple and easy to understand. And I understand that there were more talks in the pipeline. But then I think we got such talents, and we should not waste that. I'm not just referring to Ms. Kwok, it's just incidental. There might be many other speakers who might be equally skilled. And of course, on that occasion, it lasted for about 1.5 hours. And for members of the public, they might find it somewhat difficult to attend. But then if she can come up with a compressed version or a simplified version that can be uploaded onto the web to teach everybody how to use that system, I think that would be very useful. In particular, for the different trades and enterprises, well, you might not be able to organize so many talks or seminars. And if people are prepared to spare 1.5 hours, then that would be nice. And on that occasion, I tried to get the credit, and therefore I was prepared to spend that 1.5 hours. But then for others, they might not be prepared to spend that much time. And normally when I took such seminars, I would doze off halfway through. But then on that occasion, I didn't doze off at all. So Ms. Kwok, I'm not trying to curry favor from you, but then I think it's a very rare occasion, and I think there might be many others who are equally tactful and skilled.
So I think you should provide more such learning opportunities for the public and enterprises, so that after the seminar they can understand all the features available. We must not waste the platform. Of course, people can read the manual. Well, for iPhone, there is also an elaborate manual. And I think after the seminar, everyone should be okay. I think if our assistants can attend a seminar, then very soon they'll be able to use the functions available for research or for whatever purpose. So I'm very grateful to Ms. Kwok for giving the seminar. Mr. James Stowe stressed that you can shorten your 1.5 seminar to 15 minutes, or well, you can also produce videos. I'd like to know how long your videos are, and can you have some abridged version? Have you already prepared that? Are you planning to do so, Ms. Kwok? We have simple PowerPoints. How long are they? Just a couple of minutes. However, the slideshows do not have a real person lecturing you, but we have included all the buttons and icons. So in 16, we have slideshows and videos here. Different search functions. We have prepared slideshows. So to suit your needs, you can choose the speed you like. I think it is similar to the tips they give you at e-banking. And if you've forgotten this step, you can go back one step. Then you can do it at your own pace, use these slideshows. Well, I do have the opportunity to attend Ms. Kwok's presentation, but feedback from my assistants they were useful. But if you want to have fewer complaints because not everyone has the opportunity to attend a seminar like Mr. James Toh did. Now, if you can have some videos with a real person giving the lecture, I think it is more user-friendly for most people. And then you can have a 30 or 50-minute version so that even most stupid person can understand. Mr. Toh, well, those seminars, you just videotape those seminars and you just upload it to your website. I'm sure you will have a high hit rate. Now, I sound as if I am publicizing for you, but I am not a very attentive person. I am not an expert in using such tools, but I must say that Ms. Kwok gave an excellent lecture. All right, second round, I have some follow-up. I asked, what about other jurisdictions? Which jurisdiction recommended this to you? To the fact that you decided to replace it, to replace Bliss with this. I just want to know this. You're now tackling the complaints very positively, and I think because of the number of complaints received, and perhaps Ms. Kwok or an experienced member of your team should prepare a video, because you have spent so much on this. You should ensure that everyone who needs to use it knows how to use it. I'd like to know whether it is recommended by any other jurisdiction.
Ms. Kwok addresses that particular point. I believe that the colleagues who have been involved in building HKEL have much to be proud of, and I would say that we will look further into the suggestion that there be a short abridged version of the training session where there's a real person involved.
Okay, thank you, Ms. Johnson. Yeah.
係啦，咁都講一講先啦，因為司法管轄區。
Well, Hong Kong has to deal with bilingual legislation, so we cannot just buy products from the mainland, or from the market or from other jurisdiction. In our tendering process, we put a lot of emphasis on having a customized system tailor-made for Hong Kong. So to answer your first question, Madam Chair, we didn't actually buy successful products from other places. We have gone for highly customized products, and every year there is a conference. People who are my counterparts from different jurisdictions will share our experience, because Hong Kong has been slower in introducing this kind of platform. So we've learned from other jurisdictions' experience. We want to let users understand the beauty of the system earlier. All right, to follow up, when do you expect that the other system can be phased out? Or perhaps there are merits in having two systems, because the old-fashioned people can continue to use Bliss and you have less complaints.
Thank you, Madam Chair. I think it would be difficult to think that Bliss would be run in tandem with HKEL on a long-term basis. I just don't think it's practicable. However, until people are happy, and until, in fact, DOJ is very happy with the new HKEL system, Bliss will still be in place to provide that sort of safety net.
好，毛主席。
係主席，或者補充少少喺
Mr. Mo, we intend to have the two systems running in tandem in the near future, but then resources are involved in working both systems simultaneously, because we have to ensure that both are update, so that would have resource implications. So we have to strike a balance. We want through our promotion and training, more people can get accustomed to the new system, and then we'll review the situation. If people are used to this new system, then we will review how resources should be spent. And we can undertake that sufficient notice will be given upon suspension or the phasing out of Bliss. Yes, that is important. Otherwise, you will receive complaints because they can't use Bliss anymore. So I hope that you can achieve your objectives earlier in the market. Publicity is important. Please consider who are your target customers. You have to respond to their feedback ASAP. I mean, the system has to be fast enough, otherwise they will complain. Dr. Fernando Zhang, we are closing on this item, but I will give you 2 minutes, all right? Thank you. Sorry, because there are too many meetings running at the same time. Well, we have a few difficulties. First, we cannot go to the PDF version, although this paper has addressed it, but I think this is still a problem. And for the new interface, there is very little new information. For Bliss, yes, the system is older, but at least they can tell you the Gazette number, the date of different sections. And if we try to Google the new legislation, then we'll always be told that, sorry, we cannot find your page. And if we go back to Bliss, it will be successful. So I'd like to know when these 3 problems can be overcome. And I heard that Bliss and the new system will be run in parallel for a while. And according to a Bar Association, this is a teething stage. I'd like to know how long the teething stage is going to last. For instance, can you allow us 1 year to learn and to get used to the new system and see what is the hit rate and for the 2 systems, and then you can consult users. I know you've spent more than $100 million on that, but I hope, well, because for the new system, there are too many negative feedbacks. Mr. Toh said that it was okay. I hope that after we get used to it, it is really okay, because I've heard too many negative feedback comments.
Ms. Johnson?
Yes,
yeah,
just in terms of
because time is very tight. Yeah.
Yes. In terms of the number of PDFs, we currently have about 70% of PDFs available through HKEL. Into the future, we will have a direct link back to Bliss from the HKEL website for PDFs that are not contained in the HKEL website until they are there. So that's the first question.
Again, may you speak closer to the microphone? Yeah, please.
My apologies. In terms of the Gazette number and the date, that information is in fact available in HKEL. Perhaps we may demonstrate that to the member after the session. In terms of Google hits, that was an initial problem, but now we will find that HKEL search results appear on the first page and generally at the top of the first page of search results. Action was taken in order to achieve that. In terms of the length of the teething stage, I think it's difficult for me to comment on that this afternoon. We need to see what happens as we resolve these issues and we work with our users. I take on board your point about consulting with people before we in fact switch only to HKEL.
Okay, thank you, Ms. Johnson. 我哋呢個項目一定要結束啦。咁呢，如果再有咩意見，我諗呢，大。
Thank you, Mr. Johnson. And I really have to end the discussion of this item. If you have further views, do reflect to the drafting section of DOJ, and we expect to see more progress in the short term. Thank you very much. Next, item 5. Prosecution work in the magistracy direction for the future, paper CB 41022/161707. First, we invite Mr. Keith Young, Director of Public Prosecutions, to brief us on the prosecution work in the magistracy, and then we will invite representative from the Hong Kong Bar Association to express their views before I give the floor to members. Mr. Keith Young, SC, Director of Public Prosecutions, please walk us through the paper. Mr. Young, please. Thank you, Madam Chair. Thank you, members of the Council. We have detailed our position in the paper submitted to members. I will just highlight the salient points. In fact, we have prepared hard copies of my speaking note to save time. First, the purpose of this paper is to report to members on the outcome of the consultation conducted by the government on the future development of prosecution and the magistracy and the approach that the government intends to adopt in taking the matter forward. At this stage, prosecution work in the magistracy are mainly done by the court prosecutor grade and government counsel and Viet counsel. The CP grade is also responsible for case management, and the CP doesn't have to be legally qualified. However, the DOJ will provide 9 months of intensive training for new recruits.
The court prosecutor was created in 1976, and all along they've been playing a very important role at magistracies, and their contribution to the criminal legal system cannot be denied. But then, because of the change in circumstances in 2007 and 2008, with regard to the CP system, there was a round of review. And then in 2008 July, we announced the principles relating to the CP grade, and that would include that even if it's not possible to implement it in the short term, in the medium to long term, most of the prosecution work should be done by those with legal qualifications. So the bulk of prosecutions ought ideally be conducted by the legally qualified, if not in the short term, then in the medium to long term. We already expect that in the short, medium to long term, we should be looking at the principles, and we should explore ways to achieve that. At the time, the DOJ reached a consensus with the two streams of the legal profession, so that for the newly recruited CPs, unless they are legally qualified, they would only be allowed to implement or be involved in general legal duties or court duties, for example, issuing summonses and so on. And then after the meeting in 2008 and 2009, in accordance with that consensus, we conducted a round of recruitment for CP, and 13 court prosecutors were recruited. So that's batch 19 of the prosecutors. And the above-mentioned principle and arrangements have been implemented for several years. On top of that, batch 19's CP's wastage was very high. Now we only have 3 remaining, and therefore there is a need for us to review the situation to further improve the prosecution work at the magistracies. And in conducting this review, the main considerations include 4 points. First, court prosecutors' contribution to the criminal court system should be fully recognized. Second, the total number of court days for magistracies has been increasing, and because of the large number of cases, and also because the nature of such cases is relatively simple, and if they are all dealt with by professionally qualified lawyers, then that would not be cost effective, and it's also not practicable. And also, if you look at the wastage rate of the CP grade, it's very high. And since the arrangements have been put in place in 2008 and 2009 in conducting the recruitment exercise, we believe that if it's to be continued, it would not be feasible because, as I said, the recruitment principles are that the duties of the CPs would be very limited and therefore is professionally not challenging. And as a result, that might also result in people getting equal pay but not equal work, and therefore it's not feasible for us to continue to recruit on the basis of the 2008 and 2009 exercise. And also for the Fiat councils, they are not able to replace the work of the CPs, including the internal case management duties. They are very important, but then because of the nature of that, that cannot be outsourced, and therefore, and also they cannot be dealt with by GCs, i.e. government councils. And based on the above considerations, and also based on the 2008 principles and the further recommendations by the consultation document, and also after considering all the factors and feedback collected in the consultation exercise, we have now come to the conclusion, and we have the following recommendations to make. First, in terms of our actual operation, there is a need for us to maintain a reasonable number of court prosecutors so that they would be dedicated in undertaking prosecution work at the magistracy and the related work. The crux of the matter is how do we appropriately distribute the cases to those who are legally qualified and those who are not, but then that they are court prosecutors. B, well, all along, other than batch 19, as I said, only 3 are remaining. Court prosecutors, in principle, can deal with cases of any nature and classifications. And in the consultation document, we propose that we should restructure the arrangements so that we can come up with a so-called scheduled duties, so that whether they are new recruits or incumbent court prosecutors, these cases will no longer be taken up by them. Instead, these cases will be dealt with or handled by Fiat councils or in-house councils who are legally qualified. And also at the magistracies, we'll be deploying an SPC or SCP so that they can take up such duties. So in the first batch, no less than 3 senior government counsel will be deployed to join the team of court prosecutors at the magistracy level. We will also continue or resume recruitment on the basis of the scheduled duties list so that in 2017 and 18 we can start a new round of recruitment exercise. Here I'd like to bring up several points for members' consideration. First, we have received feedback from the 2 streams of the legal profession and also the duty lawyers service as well as the judiciary's comments. In principle, they recognize that prosecution work should be done by those who are legally qualified, and they also generally support that we should deploy senior government counsel to the magistracies. But on this, our stance is that through a proper scheduled duties list, the relevant cases will be taken out of the duty list of court prosecutors. We should also step up the involvement of government counsel in prosecution work at the magistracy so as to implement the principle that we read or the consensus that we reached earlier. That is, well, the bulk of prosecution work should be done by those who are legally qualified. And this is just a medium-term or interim measure. As I said, in 2007-08, we already expect that there would be short, medium to long-term arrangements. And also, with regard to the new policy on the guilty plea cases, on the sentencing discount policy, well, the situation is still far from clear. And we hope that after the recruitment is done on the new arrangement, it depends on whether or not we can recruit the right number of people on the basis of the right qualifications, and we will then be able to come up with a more long-term view. Third, the main duties of the DOJ is to maintain the prosecution standard, but then in assisting the less experienced barristers in developing their professionalism, we also play a very important role. Fiat cases or outsourced cases would be required to meet the needs of our job, and also to make sure that we can build a strong team of locally based barristers, so that they would have more opportunities to appear in court and to practice their professionalism. We would also like to nurture a group of experienced prosecutors in order to support the work of the DOJ. Of course, at this stage, we are not able to quantify the number of cases under the scheduled duties list. And second, with regard to the sentencing discount policy for guilty pleas, to what extent would it affect the number of such cases? But then with regard to the scheduled duties list, which would limit the number of cases to be taken up by court prosecutors, we expect that for fiat cases at the magistracy level, the total number will not be reduced. Fourthly, well, prosecution work should be cost effective. That's something that should not be ignored. But then that's not the determining factor on this occasion. Well, sorry, Mr. Keith Young. Well, I have to get the consent from members because it's already 6:15. So can I suggest that the meeting be extended by 30 minutes? All right, any comment? Madam Chair, because we have all read the paper, and I think he might as well cut short his speech, because we'd like to allow enough time for members to ask questions. In fact, I'm already concluding my statement. Yes, Mr. Lam Kwa Hong, you'd like to queue up to ask questions? Yes, we would also be inviting the Bar Association to speak before we open the floor to members for questions and answers. So if you don't object, then we'll extend the meeting until 7. All right, Mr. Young? Yes, I'll be concluding, Madam Chair. Concerning the relevant paper, we have discussed that with the two streams of legal profession and also the judiciary. The judiciary already confirmed that is not going to object to the recommendations, and the Law Society also gave a positive response to our recommendations, and we have already had many rounds of discussions and communications with the Bar Association. And if the AJLS panel does not have any objection, then we will act in accordance with the recommendations of the consultation document in implementing the details. So that's my opening statement, and I welcome members' questions. All right, thank you, Mr. Young. Now, Mr. Graham Harris from the Bar Association.
I'm very happy to tell you that Mr. Young, the director, is quite right. We've had useful and constructive dialogue in relation to the proposals. Conceptually, we don't really resist the proposals. Wearing another hat, obviously, the Bar Council wants to protect the position of the junior bar, because traditionally junior barristers have developed their practice in the Magistrates' Court, being briefed on a fiat to prosecute, and it's in the public interest that they continue to do that. We respectfully agree that having a senior government counsel in place in various magistracies is something that is to be welcomed. We think that's a very good idea, and we get a great deal of comfort and reassurance from the indication that the director has given in his opening statement that the work available on fiat to the junior bar will not be reduced. We see this as being consistent with an overall committed position that the bulk of prosecution work should be undertaken by people who are legally qualified. And if you have a look at the schedule to the director's paper, you'll see that the list of various matters in that schedule is fairly comprehensive. And we're pleased to see that certainly contentious issues, it is proposed, would be prosecuted by people who are legally, professionally qualified. So without wishing to be seen as over-protectionist in looking after the junior bar, we welcome these proposals. We welcome the dialogue that we have had, and Mr. Young and I have agreed that that dialogue will continue beyond the matters contained in this paper. So we do not resist these matters. on the understanding that the work that will be available to the junior bar is unlikely to be reduced.
Okay, thank you, Mr. Harris. 而家係委員發問嘅時間，暫時有。
All right, the floor is now open. We have 5 so far, so 4 minutes each. Mr. Alvin Young. Thank you, Madam Chair. Thank you, Mr. Young. I'm one of the beneficiaries of what Mr. Harris SC just said, because I was one of the Fiat Council undertaking prosecution work at the magistracies, and I've also benefited from the advice given by the court prosecutors who are very experienced, and therefore I'm grateful to the court prosecutors who have helped me, and I do believe that there is a value for them to continue to be there. But then I'd like to ask a bit about the details. Well, for the Mainland case, what's the impact on the prosecution work undertaken by the DFJ? Well, I understand that in terms of listing, as the director said in the paper, in fact, it's been more expeditious. And as a result of that, well, the pressure on the prosecution would also increase resulting from that. But then the paper has not mentioned that in detail. So can you tell us what's the observation of the DFJ on this with regard to the pressure on prosecution? So where would the pressure come from? And for the new batch of court prosecutors, if we manage to get a new batch of court prosecutors, then to what extent would they help? Yes, Director? Thank you, Mr. Young, for your questions. First, well, 30 years ago, I also benefited from court prosecutors' guidance. With regard to the Mainland case, what we can see in terms of impact is that there would be 2 folds. First, in the Mainland case, with regard to magistracy cases, after the plea given by the defendant, if they choose to come up with a not guilty plea, and afterwards if they change their mind to plead guilty, then with regard to the 1/3 sentencing discount, that would not be applicable. So in this regard, what we can see is that the defense strategy would be that on the first occasion, when they appear in court, they would say to the court that they'd like to ask for an adjournment so that they would have more time to consider the case before deciding whether or not they would plead guilty or not guilty. So in this regard, we don't think it's a problem. We believe that it's an appropriate approach.
But the problem is, from first mention to there will be a few more sittings, and all these will have to be handled by our CPs. And if the court allow another mention, then if the defendant pleads guilty, that's okay. Then the other side can proceed to mitigation. But if there is no plea at all, then the court will feel that it's a waste of court time. So the court will allow another mention. But if the defendant decides not to take any plea, then it will be regarded as a pre-trial. So we would only will only have to prepare the case assuming that there would be no plea. So a lot of time will be spent on agreeing on the facts of the case, and then maybe subsequently the preparation need not be used. That will add to the workload and pressure of our CP. And once the defendant decides not to plead guilty, then it's quite rare that they will change their mind before a proper trial. And before the Mainland case, in the court of first instance decides to have a formal trial that was 6 to 6.5% after Mainland's case. It dropped to 6% drastically. And as a result, the court listing time or the court time would be much lowered. I was just told that in a case, the listing time was only 5 days. Yes, 5 days afterwards, the case would proceed to a trial. So there would be pressure on both the defendant and the prosecution. So we have to consider the impact on our system arising from Mainland's case before we decide what is the pace forward. Well, time is up for this, and we may have the opportunity for you to supplement Mr. Dennis Kwok. Yes, I think we agree that all prosecution work should be done by legally qualified persons. However, we also agree that in terms of operation, we do need CPs to take on some of the work. So we do understand that. In reality, we just want to strike a balance. Mr. Graham Harris talked about ensuring that the work for a young counsel will not be jeopardized, and we also hope that by and by the opportunities will increase for young counsel. But for students that have taken LLB, they may not be able to transit to PCLL. Perhaps they have not done very well in LLB and they cannot get a place in PCLL, but that doesn't mean that they cannot be successful lawyers in the future. I've known many successful lawyers who didn't do well in LLB. We should not waste talents. So when you recruit CPs, can you consider recruiting graduates of LLB but who have yet to take PCLL so that they can continue to pursue their dream as lawyers? So you should not just believe in famous brands. LLB from Oxford may not necessarily be very successful. So regardless of the college, I think they can still be very outstanding lawyers in the future. So can you give priority to those with LLB qualification when recruiting CP so that they can become lawyers in the future? Mr. Young, yes, we have considered this when we consider our list of recommendations, but then if the entry requirements do not require graduate qualifications, then we have understood from CSB we cannot put this as one of the recruitment qualifications. In 2007, in our recruitment advertisement, we said that no graduate qualification or legal qualifications were required. But looking back, candidates that had legal qualification could directly go to our interviews. So we may not need to spell it out in our recruitment advertisement, but those with a legal background will certainly enjoy an advantage when it comes to actual screening. So you may be able to do that practically, but you cannot put it in black and white. I think that's the meaning of the director. Yes, please go on. And I don't want this profession to be regarded as one that would be monopolized by those who have LLB qualification but who have failed to get an PCLL qualification. We don't want this label for the grade. Mr. Poon Siu Ping, thank you. There are about the establishment of CP grade is 102, and you haven't been recruiting any new officers since 2008. Now, if this is the case, I don't think this is fair to the grade. According to para 35, you're going to recruit 10 first. So why don't you recruit the number according to your original establishment? And you are going to have a designated list. I'd like to know whether you have a draft for that designated scheduled duties already. Yes, we have a draft. In Annex C of the consultation paper, we have a very detailed draft of the scheduled duties. As Mr. Harris said, this is quite a comprehensive list. Yes, the current establishment is 102, but the current strength is 72. In the first round of recruitment, we plan to recruit 10. But don't forget that we will place 7 senior counsel back to this team. So 72 plus 10 plus 7 will be close to 100. And I think one senior counsel may be able to oversee more cases. The judiciary is proposing e-submissions of documents. That is, documents should be scanned to become e-documents for submission. We believe this is going to increase the workload and pressure of our CP colleagues. And we will consider employing more. And if resources are required, we will secure resources in our resource allocation exercise. We will keep track of the workload and also the strength. Thank you. Mr. Leung Kwok Hong, thank you. So it's confirmed that CPs will not be prosecutors in court. No, that's not the case, Mr. Leung. At present, theoretically speaking, CPs can take charge of all cases regardless of their complexity. But under the scheduled duties, we have cases that are more complicated, whether it be the legal points involved or the charges involved. Such duties will be taken out and reserved for lawyers or counsel, government counsel or fiat counsel or CP with legal qualifications to take on. So even outside the scheduled duties, there are still many other cases, such as shop theft, common assault. These cases can still be handled by CPs. So we want the proposal to be more flexible. We want cases to be handled by government counsel or fiat counsel and also legally qualified CPs. Well, in July 2008, you reached a consensus or agreement with two legal bodies. For newly recruited CPs, unless they are legally qualified, otherwise they will just be responsible for management and miscellaneous summonses. So you talk about miscellaneous summonses. Yes, littering, for instance. Well, to put it simply, so for miscellaneous summonses, they are being handled by CPs. So are they the only cases being handled by CPs? So miscellaneous summonses, right? We are talking about batch 19 CPs employed in or recruited in 2008-09. Only this batch are subject to this restriction. But those employed before that date are not affected by this. So for batches 1 to 18 CPs, theoretically speaking, they can handle all sorts of cases. But for batch 19, recruited in 2008-09, they can only take on the duties specified here. So you have 18 batches that will continue to be able to handle all cases. And for batch 19, only 3 CPs are still here. That means you have not changed anything at all. If we can recruit new CPs, then they will continue to be affected. According to Mr. Dennis Kwok, there are people who have studied LLB but have yet to acquire PCLL qualifications. Can you have a rank of senior CPs so that because they are legally trained? For more senior CPs, they are promoted from within their grade. They may not be necessarily equally qualified.
Unless they have pursued legal studies during their spare time, they would not be legally qualified even if they have been promoted to the SCP post. All right, I think this is not desirable because after 10 years, all right, for the incumbents, you will ask them to continue with their work. And then for the new recruits, they will not be required to do that. But then, as we have said many times, we are strongly against CPs undertaking criminal prosecution. Well, they might be very experienced, but then there is a chance that they might make mistakes because they've been doing a lot of work. And they are also specialized in case management. And therefore, under paragraph D, as you said, well, given the substantial case volume with a high proportion of them being legally less complicated and relatively straightforward in nature, these cases cannot be outsourced, and they also cannot be dealt with by government counsel. In other words, what they deal with, in theory, can be undertaken by legally qualified lawyers, but then in practice it's not feasible. Is that the case? No, because after the reform, court prosecutors, comparatively speaking, well, if you look at the duties outside of the scheduled duties list, in terms of the need for them to appear in court, it would be a lot less frequent, and therefore they would have more time to deal with in-house matters and also case management and also internal administrative work. That's why after the reform, the purpose is to rationalize the duties of the CP grade. Yes, we will have to move on. Next, Holden Chow. Thank you, Madam Chair. I think we have to strike a balance because court prosecutors in the past indeed can help the courts to deal with some of the caseload, which would be relatively less complicated and more straightforward. It has nothing to do with their ability. I think we have to be fair to court prosecutors. I think the crux of the matter is they don't have legal qualifications, but then after accumulating some experience in court, I believe that for the less complicated cases, for example, for the less complicated cases, they should be able to deal with them, and therefore we should not go against them taking up such duties in court. And according to my experience, court prosecutors also suffer from a high wastage rate, and there are different reasons for that. And one of the reasons, according to my understanding, is that they might be too focused on a particular type of case. For example, I just said that like illegal parking and so on. Okay, if in the future we'd like to retain this group of court prosecutors who are very experienced, so what are the ways and means to keep them? And will this reform be changing the situation so that we'll be able to retain these CPs because they do contribute a lot to the system? Yes, this is also one of the considerations because when we look at the wastage rate, well, recently there are two main reasons for them to quit their jobs. Because if you look at the job nature, is not very attractive. There is a lack of professional challenges for them, and that's why if you look at batch 19, well, we only have 3 remaining. On top of that, as I attempted to explain just now, when you have a situation whereby you get equal pay but not equal work, then for the incumbents, that would also deal a blow to their morale. That's why we don't want this to happen again, whereby people would be getting equal pay but not doing the same job. So that we respect the principle as agreed in 2007 and 08, we would like to reach out to the court prosecutors who are not legally qualified, but then they would be kept because we would like them to have sufficient professional challenge so that the job would remain sufficiently attractive to them, and then they would be incentivized to stay in their post. But then one of the important considerations is, as you said, well, that might have been our intention, and yet it's still up to the applicants to decide if they want to apply for the job. So we will have to make an attempt to start a new recruitment exercise to see if we are able to recruit the right people with the right caliber, so that they will have the right caliber and right aptitude to do the job as court prosecutors. Next is my turn. First of all, I am interested in knowing this. In the past, most of the court prosecutors would have a particular academic background. So, can you generalize that? Can you give us the general picture as to who would be more likely to be interested in becoming court prosecutors in the past? That's point number 1. And number 2, for these court prosecutors, I understand that some of them might pursue part-time law or legal courses on the job because they are interested in pursuing a career in the legal profession. So after completing the courses, for example, they might have enrolled into these courses on part-time day release. So would they invariably quit their jobs after completing those courses because of a better prospect and future and income? So you might have nurtured these talents. So we do have such schemes available so they can get on-the-job training so that they can get promoted afterwards. So is that the case? And also, court prosecutors definitely have their role. So it's like the advisors or consultants in the law firm. They might not be legally qualified, but then they might give advice to the lawyers in the firm. Well, at CityU, I've been teaching legal studies, and I can see that for the 3 law faculties, they have nurtured many talents. So let's set aside those who have not completed PCLL. Well, for those who have enrolled into the junior bars, the number is also very significant. So will you be choosing from them? And will they be deployed to prosecution or prosecutors' jobs? And as several members have said, they might not have enrolled into PCLL, and some of them have completed LLM. After LLB, they might have completed LLM for various reasons. They might have different choices. So these should have been your targets. But then from what I've heard just now, you might have some internal requirements. For example, you're not supposed to put up advertisements, so to speak. So can you be more flexible so that you'd be able to attract more talents? I'm sure after they pursue legal studies, some of them might be more interested in criminal cases. So can you attract these talents? And these talents might also, through such on-the-job training and accumulation of experience on the job, they might have shown that in the next 5 years they would be doing the related work, and they might have done it remarkably well, and they might have been praised by their superiors or supervisors, and then after completing PCLL courses in the future, they might be able to get promoted. So does the system allow for that? Or will they be confined in their posts to such an extent that you might not be able to attract the right talents to fill the posts? Thank you, Madam Chair. On the first question, the grade was created in 1976, and we started the recruitment many years back. And looking at the background of those of all the incumbents, well, I can give you an example. In 2008, for the applicants applying for batch 19, in the end, we recruited 13, and I do have some statistics about the background of them. Out of the 13 recruits, 1 was fully qualified. He could have practiced as a lawyer. 3 had LLB, CSPE, or JD, and for the remaining 9, they were not legally qualified. They did not have any legal qualifications, but then they had other degrees. So for the 14 recruits, overwhelming majority of them, when compared to the minimum requirement, they had higher academic qualifications. In fact, they had pretty high academic qualifications. And next, for the incumbents, what about their background? What is their academic qualification? Well, I've talked to them on many occasions, and it's really very special. They have a special sentiment or attachment to their grade. They are still working in their post not for the money, and they would not immediately go into private practice after they have got the legal qualifications. For the remaining 72 court prosecutors who are still with us, well, 6 are fully qualified, and they can practice in the private practice, and 29 already have some legal qualifications. Some have already completed PCLL, but then they have not completed privilege, and 21 have different legal qualifications, and then 28 have other university degrees. So out of the 72, 6 are fully qualified, 29 have some legal qualifications, 28 have other university degrees. So overwhelming majority of them, in terms of their professionalism, would be somewhat higher than the entry qualifications. And as I said, well, in our selection process, whether it's whether we have adopted the common sense approach or the professional approach, when you look at their professionalism or legal knowledge, we would not be screening them out. So in terms of attracting people with some legal background, but then who have yet to get the legal qualifications to practice, I'm sure by adopting the common sense approach, it's achievable. Well, yes, I'm learning while working, so sometimes it's a learning curve, and we have to learn it on our job. Yes, Alvin Young, 2 minutes. Yes, Madam Chair, I'm concerned about senior government counsels being deployed to the Criminal Prosecution Division, working at the magistracy, and how are they going to divide the labor with court prosecutors? So I'm sure you have a plan in place, but then are you sure that in practical terms the delineation of duties and responsibilities will be clear in the future? All right, from SCP-1, he'll be able to make the decision, he'll be able to call the shots, but then if there is a government counsel there, then very often I'm concerned that in terms of the duties in particular, if the defense is engaging in a discussion on whether or not he should plead guilty, then would the duty be passed on to the government counsel? So would that be a healthy situation? So I'd just like to express my concern on this. Mr. Young? Yes, thank you, Madam Chair. Thank you, Mr. Young. That's something that we have to consider in great detail. And when I discussed that with my colleagues and also with CP1s, they all share the same sentiment. That is, we will have to clearly delineate the responsibilities, or else there would be problems. So we have to understand that when the reform package is implemented, we will come up with a very detailed manual to set out the respective scope of responsibilities for each grade. For example, when a senior counsel is on leave, then who is going to act in his post? Will it be a subordinate of the SCP-1? All of a sudden, he might become as the supervisor.
All these have to be taken into consideration. And for administrative works and preparation of witnesses for cases, and the request for bound over, we of the view the SCP-1 should still be responsible for such. But for more complicated and sensitive cases involving court hearings, then we are inclined to ask the SC to be responsible. We do understand that this is important and also sensitive. We'll give due consideration to this. Thank you, Director. We have had a very interesting discussion, and we do understand that CPs are very important, and their role is certainly not light. And if there are plans to incorporate better tenants, we do welcome that.
Meeting dismissed. Thank you.